Good afternoon. The time is now 2 o'clock and this hearing is resumed. Before I continue with the agenda, is there anything anybody wishes to raise with me? Okay, nothing heard. Thank you. The next item on agenda item 6.1 then is to hear an oral representation from the University of Portsmouth. Ms. Evans. Ms. Evans?
Mr. Oscar, Heaven Jones, case manager.
Yep.
Just looking down the list of attendees, I can't see Ms. Evans on it. So whether she left the meeting lunchtime, as we speak, she just joined the lobby. So just let her know. Thank you.
Yep. I'll just pause for a moment to see if she can join us now.
Hello there.
Is that Ms. Evans?
It is, yes. I'm sorry about that. Something happened to me over the lunch period,
Right.
but I'm back.
Okay, right. What I had just said, I had resumed the hearing, and the next item under agenda item 6.1 was an oral representation from yourself on behalf of the University of Portsmouth. Yeah?
Yep, that's right. It's going to be very, very brief. Probably just take a couple of minutes or so.
Okay, that was going to be one of my questions. The other question was to just explain what I had before me at the moment, and that is the open floor hearing statement on behalf of the university from Freeths, and that is hearing document, examination document, sorry, Rep 5151. Is there anything else I haven't got anything else in the examination library, so I'm waiting for you just to give your statement.
That's right, yes, indeed. And as I say, it's really just building on what we said there, and just a few points that we wanted to make, which will only take a couple of minutes.
Okay, thank you. Please go ahead.
Okay, I mean, really just what we want to say is a very general point. The university just wants to record that it feels that it hasn't been given sufficient detail regarding the land that's to be acquired from the playing fields. In our previous representations, we've set out the particular difficulties that the acquisition will cause, and the university doesn't believe that that's been properly taken into account in assessing the amount of the land required in that area, and particularly the differing requirements relating to construction and operation. The university knows this is going to have a significant impact on them, and in light of that, for the university and for the wider sports provision that is in the area. So in light of that, the university believes that further consideration is needed and more detail needs to be provided. Now, we know from previous hearings that clarification is intended to be provided as part of Deadline 6, particularly in relation to easement strips and the amount of space that they're likely to take. We would ask that the university's land be considered explicitly as part of that, and we'd also like the applicant to consider further whether the land take in the area can be minimised, and if it can't, to provide a full explanation of why that's the case. And that's really all we'd like to say here at the moment.
Thank you very much. I didn't have any points I wanted to raise on that. Mr. Jarvis, was there anything from yourself?
So Simon Bird, QC. I'm going to ask Mr. O'Sullivan to address the points raised by the university.
Mr. Bird, can I just say, is it you who will be dealing with matters on behalf of the applicant this afternoon then?
No, I'm dealing with the university, sir.
Right, thank you. Mr. O'Sullivan. Mr. O'Sullivan.
Thank you, sir.
Thank you.
Mr. O'Sullivan on behalf of the applicant. Just in relation to the feedback provided by the university, just in terms of engagement to date, we had our first engagement with the university in July 2018. We had further meetings with the head of estates at the university on the 30th of July 2018, 7th of February 2019, and the 28th of August 2019. Heads of terms were sent to the university in December of 2019, and we have requested further meetings with the university on 12 occasions between the 9th of December 2019 and the 11th of November 2020. The response from the university on the 13th of November, and we had a further meeting on the 20th of November, and again we continue further engage. We would welcome further engagement with the university to address their concerns. In terms of the Ms. Evans' comments about minimising land take, that is obviously the preference for the applicant as well. We note the university has initially made reference to its preference to remove the Firs Lane option from the order limits. This has previously been removed, and the only remaining area within the order limits here now is on the pitches at the east side of the university campus. The applicant's preference in this area is to keep the cable route as far east as possible to minimise the impacts on the university. And just in terms of the extent of work here, the cable route in this area is approximately 325 metres. So looking at the two circuits which would be required, that is 650 metres in total. Again, the application document set out that it would be possible to install the cable route at approximately 50 metres a day in areas like this. So all in all, I think we'd be expecting about 3 weeks to carry out the works and then to carry out the reinstatement thereafter. But we note the points raised by Ms. Evans, and we're keen to continue engagement and to secure a voluntary agreement.
Thank you. Ms. Evans, was there anything further from you?
Nothing more at this stage, thanks.
Okay, thank you. That brings the representation from University of Portsmouth to an end then. The next on the list is Portsmouth City Council. Ms. Colquhoun.
Good afternoon, sir. Can you hear me?
I can, yes.
Oh, good. Okay, well, as long as you can. So, sir, I am simply going to hand over to Mr. Cunliffe. We are basing our representations on the response that was provided in the single document, which you should have before you, and deals with both CAH1 and CAH2. I have, there's one omission I have made, which is that you do not have the CVs of those officers and Mr. Cunliffe, who is Gately Hamer. You don't have those before you yet, and we will undertake to provide those for you.
Thank you.
What Mr. Cunliffe is going to do is to summarise the council's position, but also to pick up on a couple of things that have arisen over the past few hearings, just so that perhaps you'll be able to complete your note on that. So it's trying to be helpful and take it forward. But as I say, Mr. Cunliffe has got a series of notes, which of course will be presented to you subsequently anyway. So we think it's going to be the magic 20 minutes, which I promised this morning. Thank you very much, sir. And I'll just hand over to Mr. Cunliffe now.
Just before you hand over, when today's hearing opened, you referred to items 8.1 and 8.2 yes, from yes. Compulsory Acquisition Hearing 1, and you said about the movement of those, movement of 8.1 to the issue-specific hearing on Monday, I thought yes. you had said, and then in terms of 8.2, that it had not been fully addressed and that you were going to return on this. Is this where you're going to return, or will you return elsewhere?
No, sir, I'm going to write it.
You're going to write it, right? Okay, thank you.
So you'll have it fully in a written form.
So that is at a deadline 6 submission.
Yes, sir.
Yeah. So they are slightly different. In 8.1 goes to the issue-specific hearing on Monday. Yes.
Yes.
Yeah, issue-specific hearing. Oh, sorry. Say again.
So I think it was relevant where it was in the issue-specific hearing, but it also covers paragraph 8.1 as well. So in order to answer 8.1, please refer to paragraphs 3.15 and 3.16 of our transcript to that ISH1.
Yes, right. I have it now. Sorry, I got the numbers mixed up in my notes. Right. I think it was paragraphs 316 and 317 were the ones that I might have spoken about. Right. Okay. Okay, I'm clear on that now. Thank you very much.
Thank you very much, sir. I'm very grateful.
Mr. Cunliffe.
Good afternoon, sir. As set out, I'm going to provide a summary of our submitted transcript. For the record, my name is Ian Cunliffe. I'm a director at Gately Hamer, and I'm instructed by Portsmouth City Council. I'll refer to them as PCC through this oral representation, or the council. PCC, as the examining authority will be aware, is an affected person and has multiple plots affected by the proposed development. PCC is also a relevant local authority. This oral representation sets out the concerns PCC has in both its role as local authority and as a directly affected person. PCC has some overarching concerns regarding the applicant's application for compulsory acquisition powers and some issue-specific concerns that PCC requests the consideration of the examining authority. PCC considers that Section 122 of the Planning Act, which the examining authority helpfully introduced at the start of the hearing today, is one of the most fundamental and important aspects of the DCO regime, which an applicant must meet. It provides that a DCO may authorise an applicant, which of course under the 2008 Act can be a private body, not just a public authority with statutory enabling powers to compulsorily acquire land, but only if the applicant can satisfy the Secretary of State that 1. The land identified within the order is required for the development to which the consent relates, or is required to facilitate, or is incidental to the development, or is replacement land given in exchange under Section 131 or 132. Or secondly, there is a compelling case in the public interest for the compulsory acquisition. As set out in the government's CA guidance, applicants must therefore be prepared to justify their proposals for the compulsory acquisition of any land to the satisfaction of the Secretary of State. A number of general considerations also have to be addressed, either as a result of following applicable guidance or in accordance with legal duties on decision makers. These are that all reasonable alternatives to compulsory acquisition must be explored. The applicant has shown that it has a clear idea of how it intends to use the land and to demonstrate funds are available. There are no legal impediments to the implementation of the scheme. The applicant can satisfy the decision maker that the purposes stated for the acquisition are legitimate and sufficiently justify the inevitable interference with the human rights of those affected. It is PCC's position that the applicant has failed to satisfy the requisite legal tests required to justify the acquisition of land and rights in the draft development consent order, and as such, it maintains its objection to the application for powers. As a preliminary matter, as set out in paragraph 25 of the guidance, applicants should seek to acquire land by negotiation wherever practicable. As a general rule, authority to acquire land compulsorily should only be sought as part of an order granting development consent if attempts to acquire by agreement fail. The applicant has stated its intention to seek to agree land and rights sought in the draft DCO by private treaty in the Statement of Reasons, application document 22. However, PCC has set out its concerns about the paucity of AQUIND's approach to negotiations prior to making its application from the start. For example, a letter dated the 28th of November to the Planning Inspectorate. This attitude is highlighted by issues that have arisen over the applicant's dismissive approach to the owners of highway subsoil, which we expand on in this representation. As owners of land affected by the proposed development, it is PCC's experience that heads of terms were not issued until after the application was accepted for examination, and despite productive meetings held between the applicants and PCC's respective agents.
We got as far as the start of the examination and then it started to break up. I wonder if you could just continue to see what was possible and then back to it with it. If you just speak, please.
I'm sorry, so I've turned off my camera. I seem to be, I don't know whether it's my internet or your internet.
Could you come on and
Mr. Oscar, I think it's potentially your end that the problem is.
Right. Mr. Arlington. No. Right. Okay. Okay.
We're going to take a 5-minute break, if we may, to see if we can sort out the IT problems. And we will resume at 2:20, please.
Right, the time is now 2:20, and I believe I may be able to be audible now. Then, and I've been told that this sounds okay now. I've got my camera off at the moment. I will try my camera on to see if that works. And I think I'm back, and I think I can be seen, and everybody on my side seems to say that is better. Mr. Cunliffe, do I still have you online somewhere?
Good afternoon, sir. Yes, you do.
Good afternoon. Right. From memory, I had got to an element where you were talking about the examination having started, and you were talking about engagement generally. Can you pick that out from your transcript?
Yes, sir. No, that's absolutely fine. I think my point was that the council did not receive heads of terms until after the application had been accepted for examination. Is that where you think we left off?
Yes, I think so. Yes, thank you.
Thank you. And despite productive meetings held between the applicants and PCC's respective agents, meaningful progress has not yet been made to agree even principal heads of terms, and a draft easement detailing the rights sought by the applicant is yet to be issued. It is very much the experience of PCC that there has not been any demonstrable efforts made by the applicant to satisfy the requirements of the guidance, and the use of compulsory acquisition powers can certainly not be demonstrated to be only as a matter of last resort. A legal agreement is essential to ensure that the concerns PCC has in terms of the construction and operation of the proposed development are properly addressed, and PCC requests that the applicant seeks to satisfy the requirements of the guidance and meaningfully engages with PCC to reach a legal agreement before the close of examination. We now move on to some issue-specific items, which I'll take us through. The first one of which is our concerns over the extent of the order land that has been included within the application. PCC has set out in a number of previous representations its views as to the wide breadth of powers it is seeking in respect of the order land and the unjustified flexibility it seeks in order to later identify important details of the cable route. Indeed, the person who is supposed to determine these fundamental details is the contractors, who have not been identified or appointed and which have no influence upon the design of the scheme at all. This approach fails wholly to accord with the legal tests. There is always going to be a conflict to some degree in respect of DCOs and the application of the Rochdale envelope, identifying justifiable limits of deviation and the need to legally show that all the land is required. However, the applicant has adopted the circular argument that it will only seek to exercise CA rights over the order land when it itself decides in the future what land it requires, but where the arbiter of that decision is not an independent authority or third party. This does not meet the requirement to show that all the order land is required. All the above demonstrates is that the applicant would like as much leeway as possible and correlative wide-ranging power to force the acquisition of land and interest when it does not know yet what it needs. And we'd like to move on to the matter of funding, and in that respect we would align ourselves with the comments raised by Mr. Swart this morning and the concerns that he has raised through his interrogation of the applicant's funding arrangements. PCC considers that the applicant has failed to provide evidence of availability of funds required for the compulsory acquisition powers being sought, powers which are blighting large areas of the land within the order limits. PCC maintains that as a minimum, a bond needs to be put in place to ensure that the applicant can demonstrate it has the resources to fund the proposed acquisition of rights and land which are having a blighting effect on the order land now. We move on to our concerns over open space and special category land. PCC has set out in its submissions to date the impacts of up to 17 playing fields due to the applicant's proposals, and these impacts the applicant has failed to address or mitigate appropriately in accordance with the harm that would be caused. The applicant has stated that whilst it is continuing to seek compulsory acquisition powers for a term of now 5 years, it is not the case that the works will be ongoing for 5 years. That was included in the applicant's response to deadline 2 submissions, library reference Rep 3-014. The applicant stated its position in respect of the impact on special category land in the statement of reasons, paragraph 1.55, library reference Rep 1025. The applicant therefore considers that the special category land, when burdened with the rights sought in the order, will be no less advantageous to any person or the public than it was before, and therefore the test provided for at section 1323 of the Act is satisfied. PCC considers that the applicant has failed to identify the long-term impacts of the rights sought in the order due to the potential 5-year displacement of users from special category land. One significantly impacted section of the route is the very heavily utilised Farlington playing fields, which accommodates cricket in the summer and football in the winter, along with providing the Victoria Festival with an essential campsite facility. The festival is a social highlight for the city, and there are no alternatives for an equivalent campsite. PCC are concerned not only in respect to the financial losses that will result in not hosting the campsite, but the potential threat to the event that has significant socio-economic benefits. The impacts at Farlington playing fields were recognised by the applicant in the applicant's responses to deadline 2 submissions Rep-014, where it confirmed that, despite mitigation measures, Chapter 25 of the ES concludes that there are significant residual effects at Farlington Fields due to the extent and duration of the project. This acknowledgement by the applicant is in stark contradiction to the opinion in the Statement of Reasons that Section 1323 of the Act has been satisfied and the special category land would be no less advantageous. No adequate mitigation to alleviate the impacts of the construction of the proposed development have been identified. No replacement land has been provided to accommodate displaced users of special category land, and the applicant has not sought to limit, either in time or physical area, the extent of temporary occupation of land, despite stating the works would not be continuing over the 5-year period for which they are applying for powers. It is the Council's view that the applicant has failed to satisfy the requirements of 132 and 133 of the Act, and that powers should not be granted over this land. Further, the applicant has not sought to consider alternatives, including modifications to the scheme, as is required in accordance with the guidance, including the consideration of HDD beneath Farlington playing fields, to minimise disruption to the special category land and the consequential displacement of users. This year, with the impacts of the pandemic being felt across the world, the importance of sport and exercise to health and well-being has been highlighted. It is hard to imagine a scheme that could have had more of an impact on the recreational resources of Portsmouth, with no mitigation offered to offset the impacts that could last for the duration of a child's secondary school education. It is the Council's position that the true impacts of the proposed development have failed to be recognised by the applicant. Just move on to highway land, if you excuse me for 1 second. The Council welcomes the changes made at deadline 4 by the applicant, whereby the application for acquisition of rights over PCC and other highway authority owned land was excluded from the Book of Reference, to confirm previous statements made by the applicant that it was not the intention to acquire rights in highway land owned by highway authorities. However, how works in the highway are undertaken still needs to be confirmed, with the applicant reluctant to date to engage in appropriate protective provisions or enter into a 278 agreement. Further, the applicant has not changed its position in respect of providing compensation to owners of subsoil. Despite making references to other infrastructure schemes such as HS2, Channel Tunnel Rail Link and Crossrail 1, where compensation and a notional contribution to professional fees was made, the applicant is irrationally not providing equivalent compensation as the schemes it itself has identified as providing precedent to the applicant's approach. As a commercial promoter, not funded by the taxpayer, the applicant should be taking a proactive approach in ensuring that the future neighbours of the scheme are provided with an appropriate level of compensation that they could reasonably be expected to receive in accordance with the other infrastructure schemes the applicant has cited. Consideration of alternatives. It is still not clear why Portsmouth, the most densely populated city outside of London and the UK's only island city, has been chosen as the landfall point for the onshore cable. Whilst the applicant suggests the cable route encroaches into the highway as little as practicable, in certain locations this is unavoidable. Implications of cabling through the highway would in fact have a far greater impact than off-roading routing and result in severe impacts upon traffic movement with significant disruption and inconvenience to city residents, businesses and visitors. Queuing, diverted or rat-running traffic will significantly impact air quality, detrimentally impairing the ability of PCC to achieve its statutory obligations. It should also be noted that the approach the applicant has taken is contrary to the approach taken by ESSO on the recently made Southampton to London pipeline DCO, where ESSO sought to avoid highway land due to the increased likelihood of strike from other utilities accommodated in the highway and their preference to use private agreements with landowners of private land to manage the construction and operational requirements of the project. If the rationale applied by ESSO was considered to be sound, resulting in the DCO being made by the Secretary of State, the contradictory position adopted by the applicant cannot be maintained. Consideration of fibre optic cables as associated development. PCC was in attendance at the draft DCO issue-specific hearing for the discussions arising around the FOC infrastructure cabling and its eligibility as associated development. This issue is, however, of considerable significance in respect of the applicant's application for compulsory acquisition powers. PCC has explained how it believes that at least part of the FOC development is not associated development within the meaning of the 2008 Act, or indeed any development to which the 2008 Act can apply, and in light of the associated development guidance. To that end, it is PCC's belief that the Secretary of State has no power under the 2008 Act to grant CA powers in respect of the order land required for this development. PCC submits that all such order land should be removed from the DCO. Impediments to the proposed development. PCC has raised in its earlier submissions, please see deadline 4 response Rep 4036, concerns about the status of the AQUIND project in light of its no longer being listed as a project of common interest and how that impacts upon the application of the 10E regulations. Further, it is PCC's observation that the examining authority clearly needs to understand what the impact of this loss of status on the AQUIND project upon the need for consents from the French authorities. Clearly, if the prospect of the French side of the project is now under threat, that would be a fundamental impediment to the progress of this scheme overall. Fort Cumberland Optical Regeneration Station. The Council maintains the applicant has failed to recognise the impact of the temporary and permanent land take at the Fort Cumberland car park. The car park at Fort Cumberland is contiguous to and serves special category land, and PCC has argued forms part of the special category land. Regardless of whether the car park itself satisfies the definition of special category land, the users of the car park will be displaced due to the ORS building, screening and works. And thus the users of the open space that the car park serves will be permanently displaced. It cannot therefore be maintained, as set out by the applicant in paragraph 1.5.5 of the Statement of Reasons, library document at 022, that the applicant therefore considers that the special category land, when burdened with the rights sought in the order, will be no less advantageous to any person or the public than it was before, and therefore the test provided for at section 1323 of the Act is satisfied. It should also be noted that some of the displacement is unnecessary altogether, as the ORS building exceeds the requirements for the proposed development as confirmed in the applicant's statement in relation to FOC Doc 7.7.1 submitted at deadline 1. Whilst it is not possible to state with absolute certainty the extent to which the size of the ORS is dictated by the proposed commercial use, it is anticipated that approximately 2/3 of the cabinets within the ORS will be available for commercial use. We'd also like to raise at this point, sir, the question whether or not the ORS facility is required at all for such an interconnector project, and whether they've been previously adopted for interconnector projects. We would like the applicant to provide a response on that if possible. The applicant therefore needs to recognise the displacement of users from special category land in consequence of the ORS building, reduce the size of the ORS building by approximately 2/3 to ensure the land acquisition is proportional to the needs of the proposed development. Finally, PCC has raised with the applicant that they have identified permanent screening and landscaping around the ORS building, for which the applicant is relying on new connection rights. The rights sought are inconsistent with the above ground and permanent works, and the land should be identified as being permanently acquired in the land plans. The applicant's agent issued a correspondence on the 26th of November 2020, confirming that it deemed the rights sought in the draft DCO to be proportional. It seems completely inconsistent to seek to secure land permanently for the ORS building, yet the land required to accommodate screening to the building only requires the acquisition of rights. The applicant is seeking to artificially reduce the footprint of its permanent acquisition and consequential compensation liability. In summary, the applicant has not made any meaningful efforts to negotiate with PCC to address the severe and long-lasting impacts of the proposed scheme. These impacts will result in the long-term displacement of users of special category and open space land, and there has been no recognition of the consequences of the proposed scheme proposals on the users of the order land. The users of open space land and special category land and the users of local highway network have been poorly treated by the applicant. Users of playing fields will be displaced with no replacement land provided. Road users will face severe disruption and delays due to the poor routing solution adopted by the applicant, where modifications and alternatives to the proposed development have failed to be considered. Further, owners of subsoil are not being provided with compensation they are rightfully owed, demonstrating the alarming disdain for the key stakeholders to the scheme. The applicant has also failed to confirm it will have the funds that it will need to secure the land included in the DCO. The DCO seeks rights for apparatus, the FOCs, that will provide the excess capacity that does not form part of the proposed development, nor should be considered as associated development, and therefore should not be subject to compulsory acquisition powers. The applicant has failed to demonstrate that it has satisfied the compulsory acquisition tests, failed to mitigate the impacts of the proposed development, failed to demonstrate it has the funds for the powers it seeks, and has attempted to include apparatus that should not be consented under the Planning Act 2008. It is PCC's position that the application for compulsory acquisition powers made by the applicant in the DCO should not be granted. Thank you.
Mr. Cunliffe, thank you. Mr. Jarvis, was there anything in response? I am getting a bit of feedback on this. I'm not sure if that's me or if it's right. That seems to be better now. Thank you, Mr. Cunliffe. Mr. Jarvis, did you have anything to say in response to that?
Thank you, sir. We do. In the first instance, Mr. Alan O'Sullivan will address a few points, and then I will pick up on the remaining. Thank you.
Thank you, Mr. O'Sullivan.
Thank you, sir. Thank you to Mr. Cunliffe for his input. I think just in relation to the first point, which Mr. Cunliffe picked up, we don't think it's a fair account of the engagement which has taken place with Portsmouth City Council to date. The engagement with the council started in 2017, primarily in relation to surveys. my first meeting with the council's property team to provide them with an overview of the route, which was envisaged at the time, was 4th of January 2018. Further meetings took place throughout 2018 and 2019 across a number of subject areas relevant to the proposed development. As Mr. Cunliffe mentioned, the heads of terms were issued in January 2020. Had a further meeting to discuss those with the council in March of 2020, and we're yet to receive any feedback from the council on those. The representative of the council, who was the primary contact on property matters, has retired in 2019, and the applicant was informed in a meeting on the 4th of August that the council were going through a process of appointing an external consultant to pick up the property specific matters. And Mr. Cunliffe and his firm, Gately Hamer, were appointed, I understand, in September 2020. A number of meetings have taken place with Mr. Cunliffe in October and November. The applicant massively welcomes his appointment by the council, and we note that he has a lot of experience on similar matters. On behalf of the applicant, I'm currently preparing revised heads of terms, which will be provided to Mr. Cunliffe by deadline 6, along with the draft easement which he referred to. But on balance, I hope that provides the examining authority with confidence that there has been a sufficient amount of engagement with the council since 2017. In relation to the other points raised by Mr. Cunliffe, I'll pass you back to Mr. Jarvis to deal with those.
Thank you, Mr. Jarvis.
Yes, hello, sir. I will try and go through those points in turn, if that's okay, on the issue-specific points raised by Mr. Cunliffe. I want to thank Mr. Cunliffe firstly for clearly setting out the PPC's position with regards to these matters.
Mr. Jarvis, you're not coming through very well, and I have to say at this stage, at my end, it could be the volume, it could be the turning of papers that I know I often do myself.
Is that any better, sir?
That may be better, yes, thank you.
Okay, thank you. So the first point I would like to pick up on that Mr. Cunliffe raised is with regards to the extent of the order land and what he described as unjustified flexibility. We have submitted a transcript for compulsory acquisition hearing 1, where in the response to question 4.3 in particular, we have very clearly set out the reasons why we consider the land that is included within the order limit is required. We wouldn't agree that there is any unjustified flexibility. There's a limited level of flexibility included, which are the limited deviation to allow the project to be delivered. It's acknowledged that there are areas where the order limits are wider, and they are in most cases wider so that you can accommodate the compounds that are required for the HDD installations, which we have already spoken to. A further point that was made by Mr. Cunliffe is that it is the applicant that will determine, with no input from anyone else, the extent of the land that the permanent rights will be acquired over. Again, that is a mischaracterisation. The detailed design approvals that are to be obtained through the local planning authorities who have requirements for discharging those detailed designs. That will confirm the extent of the land that the permanent easement may be acquired over. And coming back to that point, again, it's not the fact that the applicant can just determine how much of the land it takes. There is a clear legal test written into Article 23 of the order, which we have already spoken about in these hearings this week, which clearly sets out the test of necessity that needs to be applied to the easement that is to be acquired. And there are notes to follow on this point, sir, further to the discussions yesterday, including in relation to what we described as the reversion. With regards to the impacts on special category land, I would like to highlight that through our best efforts, we have sought to engage with Portsmouth City Council to identify how we can mitigate the impacts on special category land, including by providing a framework management plan which looks at pitch realignment. To date, we have had very few comments back on that. It is a document that in many respects we are trying to progress ourselves. The main points that have been raised are that the restoration timescales need to be reviewed, which is acknowledged and is being looked at further, but we haven't, we feel, had sufficient engagement to actually progress those discussions positively so as to mitigate the impacts for the benefits of the residents of Portsmouth. I confirm that the applicant is considering how it may be able to do that unilaterally on the basis that it does not have confidence at this time that Portsmouth City Council will proactively engage on that matter. And with regards to the points made in respect of the test to be satisfied in relation to the use of special category land, I would just refer back to the response provided in our transcript for CA hearing 1, the answer to question 6.1, which clearly sets out the applicant's view as to how those tests have been satisfied. Just on the point of replacement land, I think Mr. Cunliffe would also acknowledge that there is no available replacement land. That's a position that's been discussed with the University of Portsmouth. It's a position that's been discussed with Portsmouth City Council. That, unfortunately, is the position. Mr. Cunliffe then moved on to alternatives and in particular highlighted that we have not explored the opportunity of a HDD beneath Farlington playing fields. To have a HDD beneath Farlington playing fields, one would need to HDD from Kendall's Wharf, below Langston Harbour, below Farlington playing fields, below the railway, and then to where exactly? Well, no one's clear, because as we can see, the longer the drill, the bigger the compound that's required. Quite simply, a HDD beneath Farlington playing fields would not be feasible. And just coming back to the point of the idea of HDDing between the two joint bays being the railway and Farlington playing fields, that in itself would be impractical and would have a greater impact and is simply something that's not feasible from an engineering perspective. Another point that was raised by Mr. Cunliffe was with regard to highway subsoil compensation and the approach that has been taken by the applicant in that respect and how that has not satisfied the guidance. The position statement submitted in relation to highway subsoil by the applicant has clearly outlined how, in accordance with paragraph 25 of the guidance, the applicant does consider it has satisfied the terms of the guidance. The guidance sets out that where proposals would entail the compulsory acquisition of many separate plots of land, such as for long linear schemes, it may not be practicable to acquire by agreement each plot of land. In these circumstances, sir, we are looking at ad medium file and presumed ownerships of land up to the middle of the highway for all of the properties that abut the highway. To seek to negotiate with all of those assumed owners of highway land would require negotiations with quite literally thousands of people. It's not practicable in any way, and that's why the applicant has taken the approach it has taken. It is also not correct to say that there is no availability of compensation for those persons, for in the rare instances where it is necessary to deviate below the vertical plane of the highway, as we have already discussed through these hearings this week, compensation provisions do apply where those circumstances arise. And again, sir, you will be aware, following the discussions with Mr. Turney yesterday, that we are looking to provide some further confirmatory statements in relation to how the position will be determined as to whether the cable is within the highway or not within the highway, and we'll be looking at whether it's necessary to secure anything through requirements in that regard. Mr. Cunliffe has also set out in relation to the consideration alternatives that it's still not clear why Portsmouth. In short, the applicant's submission is that the alternatives position is very clear. The applicant has gone through a very rigorous alternatives process. It is absolutely necessary to determine a scheme of this nature to pick points A to B. It is not the case that points A to B were picked without consideration to the route in between, and the applicant is confident, based on the information it's submitted to date, that it has made the right selection for this proposed development to deliver it in the necessary timescale. Importantly, that there were no other reasonable alternatives in these locations that would have delivered the scheme in the same time or would have in fact been less impactful. Noting that the applicant has, where there are highways impacts, sought to route off the highway where possible, and in relation to those highways impacts, has fully assessed them, has identified what we consider to be a very, very rigorous set of mitigations by way of the framework traffic management strategy to, has identified a range of very rigorous mitigations which ensure the impacts on the highway are not acceptable. And we note that Portsmouth City Council do not in any point indicate that they consider the impacts on the highway to be severe for the temporary period that they are being carried out. The position with regards to associated development has been discussed throughout these hearings. I do not have much further to add on that, save that a position statement has been submitted to set out why the applicant considers that the associated development does satisfy the guidance and can be consented as associated development in accordance with section 115 of the Act. And there are further submissions to be made on that at deadline 6, further to the discussions that we've had already. With regards to impediments to the project and the PCI status, This was very clearly explained yesterday, that the loss of PCI status is not in any way an impediment to regulatory status being obtained, and in fact one cannot obtain regulatory status through the PCI regime. It is through the European energy regulations. That was explained clearly yesterday. It will be further explained in the updates to the funding statement as we discussed yesterday, and hopefully that will further address the point. And in addition, I note that the applicant has already committed to also providing an update on the progress being made in relation to the consents to be obtained in France for the project. Next, we come to the car park at Fort Cumberland and the displacement. I would first like to highlight that the car park is not special category land. It does not satisfy the definition of special category land within section 1 through 212. That has been clearly explained in our submissions to date. Furthermore, I would highlight that the applicant has provided to Portsmouth City Council a plan which shows how the car park can be resurfaced post the works being carried out, so that it provides a car park capacity very near, if not identical, to what is there today by actually surfacing the area and marking it out appropriately. So there is actually a benefit being offered to Portsmouth City Council in this respect, and we're hopeful that they will engage on that in the future. There were various points in relation to the ORS. I have already touched on the position with regards to associated development. I would just note that this again was discussed yesterday, and it's already been agreed that further submissions will be made with regards to the reasons why the ORS is needed, irrespective of whether the commercial use goes ahead, and that will be submitted at deadline 6. Mr. Cunliffe then raised the position with regards to the landscaping rights that are sought at Fort Cumberland and the fact that they are proposed to be acquired through the new Connection Works rights class. The applicant would highlight that the area of the car park that is to be developed is identified for new Connection Works rights because they are the rights that are required to carry out the works on that land. It is not the case that the applicant sought to dual identify different sorts of rights on that land, and they have specifically identified the classes of rights within the book of reference that will be applicable. And in relation to landscaping, it is the case that a landscaping right, or subclass as I'll call it, within the new Connection Works rights is proposed to be relied on. That in no way alters the rights that are to be acquired. It is simply a semantic point. And then lastly, I have a further point that I've highlighted, but I've already covered it, so I'll finish there, sir. Thank you.
Mr. Jarvis, thank you. Just before I give Mr. Cunliffe the opportunity to respond if he wishes to, you mentioned Farlington playing fields, and I would just draw attention to the note that was requested yesterday about the impact on open space in terms of the areas occupied by works and the duration of those works. I would be grateful if, in respect of Farlington playing fields, if that could include an appreciation of the point that was made, can they be HDD'd underneath, and the implications of those for instance, the connection with the micro-tunnelling and the connection with the proposed HDD underneath the harbour. Mr. Jarvis, have I been clear enough on that?
Yes, sir, that's fine. We will address the non-feasibility of HDDing beneath Farlington playing fields in that note. Thank you, sir.
Thank you. Mr. Cunliffe, then, would you wish to respond? I mean, obviously, as I've said before, I don't want to get into a toing and froing. Is there anything that you would wish to respond to at this stage?
Not in great detail, thank you, sir. The only aspects I think might be worth sort of picking up are, in response to Mr. O'Sullivan, I would concur with him that there have been meaningful discussions with him, and I hope they will continue. I think there has been a frustration probably on both sides, whereby the technical detail that we're trying to incorporate within the legal agreement has not been able to be captured, such as duration of occupation of land on a temporary basis, and widths within the order limits, which obviously leads us in part to this hearing today. But we look forward to working with him to try and develop those heads of terms. One aspect that we will be responding to is the framework management plan. We'll be responding to that at deadline 6. But in respect of the comments made on the framework management plan, the suggestions within that document are not really mitigation. If I was to take as an example, and this is library document Rep 4026, the mitigation and management which has been suggested, and I think this covers all the open space and special category land which is affected within Portsmouth City Council's ownership. The suggestion there is for mitigation is consultation with affected users and the local authority, restoration of recreational land and open space and car parks, and contractor review of the construction programme and working areas. Now, none of those really qualify, I would suggest, as mitigation. And the only final point that I will pick up as a surveyor rather than as a lawyer is the matter relating to subsoil interests and Mr. Jarvis's comment in respect of the thousands of interests that it would not be worth engaging with to negotiate compensation. I would only add that the schemes that have been cited by the applicant themselves did themselves include thousands of affected parties who did actually ensure that the resources were available to properly compensate those thousands of affected parties. And I would question whether or not the compensation that would be due to those parties has been included within the property cost estimate, which would have informed the funding statement. Thank you.
Thank you. Mr. Cunliffe, there was just one thing that was said in Mr. Jarvis's response to your oral representation, and it was that Portsmouth don't anywhere say that highway impact would be severe. Is that something that you can respond on as to whether you believe that is the case or isn't the case, or is that something that would be better responded to alongside the deadline 6 submission covering what you've just said?
So if I may, I would default to responding at deadline 6 on that particular comment.
Right, okay, so it's responding to the contention made that Portsmouth haven't said that highway impact would be severe.
Thank you.
Thank you. Mr. Cunliffe, one final thing that occurred to me when we were going through then is that at the start of your representation, you mentioned human rights, and I was interested as to whether human rights was, on what basis human rights was relevant to Portsmouth's objection. Now, I'm not asking for a response on that at the moment, but I would be interested at deadline 6 to have a response on that in terms of how human rights issues that we covered in the hearing this morning would be relevant to Portsmouth's objection. Thank you.
Certainly, sir.
Right. Mr. Jarvis, was there anything that you wish to come back on what's just been said?
Just two very quick points. With regards to the framework management plan, Mr. Cunliffe has missed out that there are discussions ongoing in relation to the realignment of pitches and the phasing of work so as to ameliorate the impacts on the open space land, and that's principally what's being discussed between the parties currently and would provide additional mitigation where it can be agreed to with Portsmouth City Council. And my second point is that I absolutely did not say it would not be worth negotiating with those persons. I said it would not be practicable to negotiate with persons with highway subsoil interests, which aligns with the wording in the guidance. I would also identify that the potential for compensation in relation to those landowners has been included within the cost estimate. The fact is, the circumstances in which you will go into the land beneath the vertical plane of the highway is very rare, and the value of that subsoil is nil to very small, and therefore has no material impact on the land acquisition estimate.
Thank you. Mr. Cunliffe, anything further from yourself?
I think we'll leave it there. Thank you, sir.
Thank you. Right, that then concludes the affected persons that have been brought to my attention in respect of this agenda item 6.1. I now come to agenda item 6.2, which is any other affected persons wishing to make oral representations. If any other affected persons wish to make oral representations, could they please make themselves known by putting their hand up in the Teams platform? Okay, nothing heard, thank you. On to agenda item 6.3, which is any section 102 parties or category 3 persons wishing to make oral representations. In exactly the same way, if any of those persons wish to make oral representations, can you please indicate? Okay, nothing heard, thank you. Agenda item 6.4, any interested parties wishing to make oral representations on the temporary use of land, please make yourselves known. Okay, nothing heard, thank you. That completes section 6 on the agenda. Item 7, section 7 on the agenda is any other requests to speak. Are there any other requests to speak at this hearing? Okay, nothing heard. And then I now go on to updates and administrative matters, which is section 8 on the agenda. And at this point, I go to Mr. Mann for a summary of the post-hearing notes. Mr. Mann.
Thank you, Mr. Roscoe. I have no notes of specific issue post-hearing notes from this, but we would like some full notes with any necessary expansion and supporting evidence to cover what has been presented to us today by deadline 6, which is the 23rd of December. And if I run through what we are expecting at the moment from what's been offered to us today, or what we've been asking for. Firstly, for the carpenters, obviously we have Rep 5108 from you in examination already. But as discussed during the hearing, please could we have a post-hearing note from you on the alternative approach to the summarising that we heard from you today. Secondly, Mr. Conboy for Sainsbury's, we don't have anything in examination in terms of your transcript, so please could you send that in, expand and report on what was said accordingly today. Ms. Evans for the University of Portsmouth, a very simple report on what was said today would be useful at deadline 6, please. For the Portsmouth team, Ms. Colquhoun or Mr. Cunliffe for Portsmouth City Council. Clearly, we've got Rep 5086 in examination, which is very useful, but we would like you please to expand on that transcript and to report in accordance with what was said and discussed today, including but not limited to the recreational framework management plan, the severity of impacts on highways, and also on the human rights issues that were raised. On top of that and further, from the applicant, please, could we have 3 post-hearing notes to respond individually to what was said and discussed today in relation to the representations and discussions that were held in relation to the land of the Carpenters, Sainsbury's and Portsmouth City Council. And in relation to the latter, Mr. Roscoe specifically has asked for the addition of feasibility of HDD under Farlington playing fields. That's all I have, Mr. Roscoe. I don't know whether I've missed anything that you have.
Mr. Mann, there was just one thing in terms of the post-hearing note from Mr. Zwart. It covered quite a scope of items, and from the discussion that we had under that particular part of the agenda, I took it that there were possibly more items to come up rather than just alternatives. I think it was a little bit more general than that. Thank you.
Okay. Mr. Zwart, your hand is up. Do you appreciate what we're asking for you, or do we need to explain that?
Yes, that accords with my recollection of my discussion with Examining Authority Roscoe. Thank you.
Thank you. Mr. Bird also has his hand up, Mr. Roscoe. I'll hand back to you.
Thank you. Mr. Bird.
So yes, there were 2 other items in which you asked for notes on. Firstly, a note on the public sector equality duty, which we will submit by deadline 6. And you also asked for a note on the overhead line clearance, both in relation to distance and safety, which again we'll seek to provide by deadline 6.
Right, I'm happy to have those in the form of notes. I thought that the clearances were something that could just be added to the summary of what had been said, and in respect of the Equality Act. Yes, I was accepting what had been offered, but thank you for clarifying those. I'm happy to have them in either way. Right, I didn't have anything further in terms of updates and administrative matters. Was there anything from anybody else on that agenda item 8? Nothing heard, thank you. Agenda item 9, any other business? Anything from anybody on any other business? I can hear some background noise, but right, okay, thank you. I don't see any hands up. Thank you very much. Right, all that remains then is for me to thank all who have contributed to the hearing today. I think we've made good progress in terms of the hearing, and I thank you all for what you've put into it. The time is now 3 minutes past 3, and all that remains then is for me to close the hearing. The hearing is now closed. Thank you.